the internet, and welcome to content. Dun dun dun. Today on Ramblings with Rebecca, actual information. We've been more rambly than even usual of late in the past month or so, as I've been processing my first term of law school and trying to sort out in my head how I'm going to present it in a way that is remotely palatable for you. So what we're going to do is several week-long series in a row, interrelated, about the basics of the forms of international law that I have been studying, and kind of go through just bits and pieces of what I've learned. This first week is going to focus on international law itself and talk a little bit about what the heck that even means, since that is the basis of my LLM. However, I haven't actually taken courses focused on international law itself. I've been looking at subsets of international law and really delving in topically. So after this first introductory week, we will spend a week or so each looking at international human rights law, international environmental law, and interstate conflict and humanitarian law. The fun stuff about rules of war and stuff. It's really quite fun in a strange way. Anyway, but we're going to start at the very beginning. A very good place to start. What the heck is international law? Where does it come from? International law, first of all, is decentralized. There is no central legislative or executive or judicial branch or organs like we would find in a standard legal system. Standard being open to interpretation. But for the most part, in a city, in a state, in a nation, we have a central or, government that holds ultimate authority and has legislative control. And with that comes a lot of advantages when one is trying to figure out what the law is, for there to be one central source. That's not true in the international arena. Today's global system of nation states has not always been the way the world order is set up. We have had large empires, we've had city-states, we've had, who knows, random people running amok for all we know, but we don't really think that's what happened. But certainly the idea of the nation state as kind of the main unit of global organization has not always been the case. In today's world, where it is formally on the international stage, all nations are equal. We know this is not true in practical terms, right? And as far as politics go and that kind of thing, obviously the United States has much more weight in many arenas than, say, Thailand, or even the UK. Although the UK is a relatively strong state. But as far as the international order of things go, a state is a state is a state. And states are sovereign. International law, then, as a system, is entirely consent-based, formally. States are bound only if they say that they are bound. The international law has power over states only so far as they give it power. It creates a very strange system, and means that sometimes there's a lot of debate over, where jurisdiction is, and what states can and cannot do, and whether or not international law even matters at all, if it's really only what states say it is, and that kind of thing. But there is no global police force, for the most part, or, ultimate authority, which some of us are very glad of. We also don't really have an international constitution that tells us explicitly what international law is or how it's enforced. There's kind of one, but it's unwritten and, spread throughout a lot of documents and assumptions. In this way, it's actually quite a lot like the British legal system, who also have an unwritten constitution. So it requires a lot of investigative work. British constitutional lawyers are actually very, very good at international law because of this reason. Fun fact for why it's helpful to study international law in the UK. They have a tradition of that kind of approach, and the philosophical foundation of having a lot of uncertainty and not actually knowing, exactly where to go. So in this consent-based system, there is, though, a doctrine of sources for how we can figure out what the rules of international law are, and we're going to go over that. The International Court of Justice is the most prominent and probably most important international court. Of course, it only has the power that states give it, but it's rather prominent today, certainly, and has quite a big deal of oomph. Article 38 of the ICJ statute provides a list of sources: conventions, customs, general recognized principles, and judicial decisions of qualified publicists. Yes, how's that for fun? So for the rest of the week, we're going to look at those four. I know, you're as excited as I am.